Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on
You don't, you
standby.
don't, you don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced. Sylvester Lionel Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
And you'll get it in a moment.
What is the city's recommendation regarding release?
The city is requesting bail or bond amount of 500 on each of the 6 cases. Defendant has a significant warrant failure to appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption administration of justice.
Any objection, Mr. Ionetti?
No,
Yes,
Mr. Evans.
ma'am. I would like to speak. I would like to.
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Yeah, Mr. Evans, I indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appears, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where.
Before we even get into the courtroom fireworks, you need to understand exactly what kind of hearing this is. And more importantly, who we're dealing with. This is not your average arraignment. This is a repeat courtroom visitor, a self-proclaimed Moorish sovereign citizen, Native American chief, Moroccan royal tribal chieftain, depending on the day, who believes legal reality bends around whatever title he announces out loud. Today's hearings involve multiple cases, multiple failures to appear, and an argument that somehow escalates from "I miss court" to Chief Justice Roberts needs to see my secret letter.
Appear. I want to.
Sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable. To
I
ensure
can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there, because I want to prove that I'm innocent of these charges, and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg, and it's messing with the muscles and nerves because I need to keep my leg active and in motion, and they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal.
This is where the case stops being theoretical and becomes purely factual. Bail isn't about sympathy. It's about risk assessment, and the prosecution lays it out cleanly. Multiple active cases, a significant failure to appear history, an active warrant from another court. None of that is disputed. Notice how the defendant doesn't deny missing court, he reframes it. That's a common tactic in sovereign citizen arguments. Responsibility is never rejected outright, just rewritten. The court isn't interested in rewritten history.
And I will appoint Mr. Ionati while you're in custody so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way. that he can
Ma'am,
help you.
that's the whole point I was trying to make. Mr. Ionetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm
make
not
you,
forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's gonna see it. In addition to that, the circumstances and the conditions they have me in.
Here's where the argument takes a sharp turn from legal to theatrical. The defendant isn't asking for release to prepare a defense. He's asking for release to personally deliver a letter, not file it, not submit it through counsel. Hand deliver it, that matters. Courts run on procedure, not symbolism. Judges don't accept secret documents, sealed revelations, or off-the-record handoffs, especially not from a defendant claiming federal entanglements they can't discuss. This is the illusion of importance being used as leverage.
I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ionati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionetti get me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes.
Well, you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Ionetti this, he never made any motions to get the process started. That's why
There is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself.
And that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll accept it.
It's going to be extremely difficult to do that with the circumstances I'm in.
This is a turning point. The judge doesn't raise her voice. She doesn't argue philosophy. She delivers one sentence that collapses the entire performance. You have 17 warrants out of our court alone. That statement does all the work. No opinions, no emotion, just record. Courts don't operate on promises. They operate on behavior. And behavior has already been logged, time-stamped, and verified. This is why sovereign-style assurances fail. The court isn't questioning sincerity. It's measuring reliability. And reliability has already been answered repeatedly.
Because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond, due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say
I'm-
that's not a change in circumstances.
I mailed the letter out on.
Said?
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches, and it's affecting my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
Now we see a strategic pivot. When the bail argument fails, the focus shifts to jail conditions, lockdown, injury, lack of access. And while jail conditions can matter in legal proceedings, notice what's missing. Any connection to bail eligibility. The judge isn't unsympathetic, but she's bound by scope. Jail conditions are addressed administratively, not through bail hearings. This argument isn't irrelevant, but it's misplaced. And misplaced arguments don't create leverage. What's happening here is frustration meeting procedure. The system doesn't bend because it's uncomfortable, and the judge makes that clear without ever needing to say it explicitly.
Those allegations, the same
And
allegation
in
before
addition
the
to
court
that-
today. Has warrant failure to appear history in pretty much every case.
What is his
City.
date of birth? I'm trying to find him on Jabs.
My last name is Evans, it's not Williams.
It
I'm sorry.
is 6/7/84.
And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday
And
as well.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you
I'm not
please?
sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before.
Self-representation sounds empowering until reality sets in. The judge makes it clear. Yes, you can represent yourself, but no one is going to pretend it's easy, especially from custody. This is a subtle judicial warning. The court isn't blocking the request. It's signaling consequences. Filing motions, accessing evidence, meeting deadlines. All of it becomes exponentially harder without counsel. The irony is obvious. The defendant blames prior counsel for procedural delays, yet immediately runs into the very procedural wall attorneys exist to navigate. Courts allow self-representation. They do not adapt themselves around it.
And I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're gonna set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we
Better.
will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That, could you please put on note that I asked that it be sealed immediately?
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you have provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All
The
right, well,
city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean,
I
if we're
mailed
setting
it.
it for Wednesday.
I mailed the letter off Tuesday. So
Okay,
it may
well,
get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to.
This is textbook sovereign citizen escalation. When prior arguments fail, a new jurisdiction is invoked, this time to claim tribal authority. But here's the legal reality. Identity does not override jurisdiction. The judge doesn't debate heritage. She doesn't question belief. She simply brings a conversation back to relevance. Being a chief, sovereign, or representative of anything does not exempt someone from state criminal proceedings. Courts recognize tribal sovereignty, but only within defined legal boundaries. Declaring a title doesn't create immunity, and repeating it doesn't strengthen the argument.
That I would like to fire my lawyer on stand.
You don't have a lawyer, remember? We've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
I'm
Please.
not going to do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates,
Correct.
which will prolong my time in jail,
I don't know that.
possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail.
What we had discussed, I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for.
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send two different letters.
Yes,
I mean, I have to make a copy of it and
correct.
send. I have no way of making a copy from inside the jail.
You'll have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send one letter. They in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, well, can you tell the jail, give me sufficient paper so I can make two copies? Because they're not giving me the what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati and then he can make copies for both the court and the city.
Okay, Mr. Ionati, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionati.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will.
At the end of the day, this case isn't about titles, letters, or secret federal pathways. It's about accountability. The judge applied the law exactly as written. Bail was set based on documented history. Requests were evaluated based on procedure, not promises, and self-representation was allowed, with clear warnings attached. This hearing shows why courts rely on records, not rhetoric. Every opportunity was given, every argument was heard, and every ruling followed precedent, not persuasion.